The Committee on Criminal Jurisprudence will come to order. Clerk, call the roll.
Chair Smithy,
Here.
Vice Chair Wu, Representative Bowers, Representative Cook,
Here.
Representative Jones, Representative Little, Representative Louderback, Representative Money, Representative Moody, Representative Rodriguez Ramos, Representative Riddell. Quorum is present.
A quorum is present. Members will go ahead and try to hear as many of these, try to get all these bills heard. There are a couple of things I would mention. Anyone wishing to testify before the committee, please register at the kiosk located in the hallways behind the hearing rooms. If you require assistance in registering or testifying, please contact the committee staff. To accommodate those who wish to testify, we're imposing a 2-minute time limit per witness, and we would ask that you would adhere to that. I think that's all I need to say right now. So at this time, the chair would. What's that?
Oh, sorry, that's SB 27.
Okay. Chair lays out Senate Bill 2785 and recognizes Van Deaver.
Thank you, Mr. Chairman. Senate Bill 2785 is intended to expedite the process so district and county attorneys can more quickly receive the results of investigations conducted by the Texas Department of Family and Protective Services. These investigative reports contain crucial information about the allegations of alleged abuse and neglect of children, and without this information, they cannot prosecute the guilty nor exonerate the innocent. This bill would require that DFPS send a copy of the investigative report about the alleged abuse or neglect within 30 days of being requested by the district or county attorney. It must include all information, including the confidential information in the report when requested. This bill does specify that it only occurs, the request only occurs when an individual has been arrested for aggravated circumstances such as sexual assault, murder, indecency with a child, injury to a child, elderly or disabled individual, possession or promotion of child pornography. And would note that this information will not be subject to the public information request, and so it does remain confidential. So with that, I'll be happy to answer any questions I have. I think we have some witnesses.
Okay. Any questions for Mr. Van Deaver? Okay, we'll call the witness. Chair, and we'll certainly give you the opportunity to close.
Thank you.
Chair calls Courtney Shelton. And Ms. Shelton, your affirmation shows you're Courtney Shelton testifying on behalf of yourself and the Cass County District Attorney, and as Cass County District Attorney, and you're for the bill, correct?
Yes, Your Honor.
Okay.
I'm sorry.
Well, you can call me that.
Just used to that.
Need a little ego boost this morning anyway. Okay.
Thank you, Chairperson Smithy. Vice Chair Wu has just arrived, and other members of this committee.
Well, and thank you for noting that, because I need to note also that Mr. Wu is present.
Thank you for allowing me the opportunity to be heard regarding Senate Bill 2785. This bill is important for multiple reasons, but the most important of these is that it enables prosecutors to comply with their duties under the Michael Morton Act. Allow me to give you a classic example of what is happening all around the state. A sexual assault intake has come in. Child has made an outcry to her teacher that stepdad is sexually abusing her, substantiates that outcry through a forensic interview. The child is not to be known as a liar. Stepdad, the alleged offender, refuses the interview with law enforcement, but talks to with the DFPS investigator. Stepdad completely denies the allegation to the DFPS investigator and says that the child made up the allegations because he grounded her from her cell phone for looking up inappropriate things. DFPS then interviews a friend of the child who said the child told the friend that she lied about the allegations. But because of certain family code provisions requiring confidentiality, this is never disclosed to law enforcement. It never makes it in law enforcement file or subsequently the DA's file. It isn't until the case is indicted, case set for trial, and then the defense attorney brings it up to the district attorney. DA is then forced to issue a subpoena or get a court order, which then could take anywhere from 3 to 6 months, sometimes longer, to get the redacted records, which won't contain the name of the friend of the child, which is another essential witness to the case. Texas Court of Criminal Appeals has recently held that Texas CCP 3914 does not contain a knowledge requirement on behalf of the prosecution. Therefore, whether a DA's office is aware of certain mitigating or exculpatory evidence contained within a DFPS child abuse investigation or not is irrelevant for purposes of the discovery statute. Passage of 2785 would assist all prosecutors in meeting their discovery requirement under the Michael Morton Act by requiring DFPS, a state agency, to turn over all information concerning the child abuse investigation within 30 days without redactions. As a prosecutor, it is not only our duty to convict the guilty, it is also our duty to make sure that we don't convict an innocent person. This is something that is absolutely needed, requiring one state agency to turn over that information to another state agency.
Let me see if
Thank
there's
you.
any questions for Ms. Shelton.
You better shut that thing off.
Okay, thank you for being here. I need to
Thank you.
note that Mr. Cook is present. Oh, okay. Never mind. So the chair calls Maddie Beach. Ms. Beach, your affirmation shows that you are here on behalf of yourself and the McLennan County Criminal District Attorney's Office, and you're for the bill, correct?
Yes, that is correct. So I am an assistant district attorney for McLennan County. I try felony cases. I'm also the chief of the CPS unit within our county. And so this bill will kind of help us mitigate some issues that we're having right now with Michael Morton and 3914. A lot of times I receive information directly from CPS, who is technically my client, as I am partially their attorney. But at the same time, I'm also a prosecutor. And so it's very difficult for us to comply with discovery requirements if I receive information, but then also have the duty to give information that is supposed to be held confidential. So by having this bill enacted into law, we can actually mitigate those issues. We can also help expedite the process on our screening and intake process and procedures, because the faster we get this information, the faster we can determine whether or not this case or a case is good enough to go forward to indictment in front of a grand jury. It also will help us be able to share information freely within our own office, as right now I cannot do so. So I think it will be very useful, not only on the CPS civil side, but also in prosecution.
Any questions, members? Yes, Ms. Jones?
I've got a quick question.
Yes, ma'am.
You said right now you can't share information within your office. Can you explain that to me, please?
Yes, of course. So as an attorney for DFPS or CPS, anything that they tell me is technically attorney-client privileged. And so I have to be very careful not to break that privilege. But I'm also a prosecutor. So if I receive information that has to do with a crime, whether it's exculpatory or otherwise, I also have a duty to tell my other prosecutors. And so I have to be very careful with what information I give them. That way I am not breaching that privilege.
Oh, okay, so is the McLennan County Criminal District Attorney's Office, you represent DFPS, or you do?
Yes, ma'am. We also have a CPS unit within that office.
Okay, all right,
Yes.
thank you.
Yes.
Any other questions? Okay, thank you for being here. The chair calls Josh Teetons. And Mr. Teetons, your affirmation shows you're here on behalf of yourself and McLennan County District Attorney, and you are for the bill, correct?
Correct, sir. District Attorney Josh Steens from McLennan County. I want to echo what the previous two folks that testified have said in our office. To go to Representative Jones's question, this is not a local problem. This is an Austin Department of Family and Protective Services records keeping problem. Many times we will request records and not receive them, like Ms. Shelton said, for 3 to 6 months or even longer. And even that will then require additional subpoenas. It's come to the point where in McLennan County, we are subpoenaing individuals to come testify in front of the district court judges in felony matters and explain why we've gotten piecemeal records, incomplete records, or no records at all. And a very frustrating point there is they actually on the last hearing sent somebody from a San Antonio office to come testify that they didn't have those records, that they needed to have somebody from Austin come. And so we're getting the runaround. This makes the 30 days very clear. These are for major aggravated felony matters. This is not a witch hunt, as some have indicated in past hearings. These are cases that are already moving, being investigated, and we need those full records to comply with Michael Morton so that we don't get in trouble as prosecutors.
Okay, thank you, sir. Any questions for Ms. Teetons? Thank you for being here.
Thank you.
Chair calls John Moore. Mr. Moore, your affirmation shows that you're here testifying on behalf of yourself and as Gregg County District Attorney, and you are for the bill, correct?
Yes, sir, I am.
Thank you, sir.
I'm not going to be as learned as these other people. I was a cop for 10 years. I was a prosecutor in 3 different DA's offices, a defense attorney for 23 years, and now I'm the elected out in East Texas. As simple as this can be, Michael Morton requires us to turn over all the evidence to the defense attorney as a prosecutor, whether it be in my local CPS office or down in Austin or San Antonio or wherever. We're trying to fix that problem this will allow us on these major crimes to turn over this information and to be able to fully prosecute someone who does not need to be on the street. That's what it's coming down to. There are allegations out there made by young children against really bad people that we don't know about because we can't get this information. And it's taken 9 months. And as a defense attorney, if I step back and put on my other hat, if I have a client that's sitting in the jail for a year waiting on this information, and then all of a sudden the state gets this information and gives it to me a year later, that person's lost a year of their life because we couldn't get this information. That's what we're trying to fix, as simple as it is. We're not doing any witch hunts. We're just trying to fix that problem we have in this system.
Yeah, we can understand, I think, the position that puts y'all in, so.
Yes.
Okay. Any questions, members? Thank you for being here. Thank all the witnesses for coming. Anyone else here to testify for, against, or on Senate Bill 2785? If not, the chair recognizes Mr. Van Dever to close.
Thank you, Mr. Chairman. This bill, very simple. It gives prosecutors the tools they need to prosecute, these very serious cases, and it also gives them the tools to exonerate those who are not guilty. So I would ask for your favorable consideration. Thank you. Not close.
Okay. Any other questions, members? Okay, thanks. If there's,
Thank you.
we'll try to get this out, but if there's no objection, the chair will leave Senate Bill 2785 pending for now. The chair lays out Senate Bill 2794 and recognizes Representative Dutton.
Thank you, Mr. Chairman and members. It was surprising to me, but the current law on interference with child custody only applies to the non-custodial parent. Did you know that? I didn't either. I had no idea that's the way the statute was structured. And so how Senate Bill 2794 does is changes that so that it applies both to the non-custodial parent and the custodial parent as well. And so that's essentially all it does. It creates also a 3 strikes policy where under the current statute, a non-custodial parent, however, could be jailed, be sentenced to a state jail felony for interfering with child custody. And what this bill does is simply says that we're going to make it a 3 strikes rule for both custodial and non-custodial parents. That's essentially all it does, Mr. Chairman and members. I'll be happy to answer any questions.
Okay. Any questions for Mr. Dutton? Not, we'll give you the right to close.
Thank you, Mr. Chairman.
Chair calls Rod McCall. And Mr. McCall, your affirmation shows that you're here testifying on behalf of yourself and that you are for the bill, correct?
That is correct. I'm a little flustered. I apologize. I wasn't expecting to get called so quickly. I have been a school teacher. I am a licensed professional counselor, and I'm also been divorced. And the idea that a parent can mess with custody is kind of a big problem. Most times, mom and dad, when they get divorced, they can put their anger and hostility off to the side. But sadly, that's not the case all the time. And in this particular case, I like this bill because it puts teeth into a statute that is already on the books, that if mom or dad messes with visitation, that it gives law enforcement and district attorneys the opportunity to increase the punishment rather than go straight to jail time. And as a result, like I said, I was going through my divorce. This was an occurrence that happened more times than I wish it did.
I've seen this happen for many other individuals. And the children that I work with, they've had, it happens as well with them. So I like the idea that the increasing of punishment so that way, well, kids have an opportunity to have a relationship with both parents. As a friend of mine likes to say, divorce is to end the marriage, it is not to end the family. Thank you.
Thank you, Mr. McCall, for being here. Let me see if there's any questions. Thanks for being here. Chair calls Bella Rockman. And Ms. Rockman, it shows that you are a neuro psychotherapist, and here testifying on behalf of yourself, and you're neutral on the bill, correct?
Yes, sir.
Okay.
Good morning. Thank you, Chair Smithy, and thank you to the committee for taking a moment to listen. I'm Bella Rockman, and I work as a licensed clinical neuropsychotherapist, and I also work as a media mental health care commentator. And I'm here today on behalf of Bill 2794. Unfortunately, all parents don't always act in the best interest of children and with maturity and social and emotional intelligence after custody orders are decided. And this is not a gender issue. I think this is gender neutral. This can happen with either dads or moms. And unfortunately, sometimes children are weaponized, and custody orders are used to weaponize to do something called post-separation abuse, which is sort of a retaliatory approach against another parent as sort of a punishment or a way to continue to control and create disruption. The Center for Disease Controls tells us that when trauma happens, more important than the trauma itself, it's how it's responded to in the aftermath. And I think that we have an opportunity here with this bill to add an exception to the bill to help to protect parents that might be in a situation where they're actually avoiding or fleeing family violence or domestic violence for safety. So adding that exception, I think, would help to strengthen the efficacy of the bill and help to provide support for families and children that have experienced trauma already, but providing more clarity. Also, the San Antonio Police Department, for example, says that there's about 1,000 calls a month that come in around custody interference issues. So I think that adding an exception to this and moving the bill forward would also be helpful because it can allow our law enforcement agents to focus on what they do best in protecting our communities. And sometimes in the presence of clarity, it helps to eliminate confusion. Okay, that's the other. So I also want to say that I do also unfortunately have personal experience with this. In my own post-divorce situation, there were over 24 custody interference reports and calls that were made, and a bill like this, with the exception, could have added a great value and support. Thank you for listening, and if you have any questions, I'm available.
Thank you for being here. Any questions from, is it Dr. or Ms.?
No, Mrs., thank you.
Mrs. Rockman? Okay. Thank you for being here. I need to recognize that Representative Bowers is present. Thank you. And the chair calls Jennifer Mudge. Ms. Mudge, your affirmation shows that you're here on behalf of the Texas Council on Family Violence, and you're neutral on the bill, correct?
Yes, that's correct. My name is Jen Mudge. I'm a public policy manager at the Texas Council on Family Violence. I'm here to testify on SB 2794. At TCFE, it's our practice to testify on a bill anytime we're attempting to work with the bill author to potentially change the language to better support victims. We really appreciate Senator Paxton and Representative Dutton's support of victims of sexual assault and family violence, and want to thank the staff at both offices for being responsive and solution-focused with the issues that we've raised. We absolutely understand the importance of parties following custody orders when children are safe. However, we have concerns about how the bill, as it's currently written, could unintentionally impact victims of family violence. Victims are the expert in their own experience, and as such, they're often able to recognize when violence and lethality factors are escalating before others can see these signs. As the risk increases, they often must make the difficult choice to flee their home to ensure their safety and that of their children. Fleeing is a stressful time and is known to be one of the most lethal times for a survivor. Therefore, it's imperative to their safety that victims are able to choose when and how they flee without the fear of criminal prosecution. As written, the bill does not currently contain an exception for cases of family violence, so our request is simple, to add that exception for survivors who are actively fleeing. Penal Code Section 2503 already has substantially similar language in place under C2 for cases where the child is taken out of the country. Should the committee recommend this bill move forward, we would just ask that the exception in 2503C2 be modified to include provisions under A and B. This would ensure that victims are not held criminally liable when they flee violence. Without an exception, victims would face the impossible choice of facing criminal charges when fleeing for their life or staying in a home that they know is unsafe to avoid criminal charges. We're confident these suggestions will ensure the goals of the bill are still addressed while keeping victims and their families safe.
Thank you very much. Any questions for Ms. Mudge? Mr. Cook?
Just one question. Do you know if your organization or any other organization had made this request prior to this bill being filed?
I'm not sure. I don't know if we've had past work on that. I would have to look into that for you.
It just seems ironic to me that y'all are only bringing this concern forward now that this statute intends to apply to mother or father. So if this was a situation that was important to your organization or someone that was, in your shoes, it seems like y'all would have brought this forward prior to this bill being filed.
Yeah, I do know that we've had past work around custody statute, that we know that there's been that single piece in there that does cover attempting to flee violence. And I know that our organization has definitely prioritized having, the ability for survivors and victims to be able to flee as needed. So I can definitely look deeper into our work in that area.
Thank you.
Thank you, Ms. Jones.
Thank you for bringing up this very important issue. And as you've said before, you're absolutely the most likely to be murdered when you're trying to get out. And to have to, and sometimes you got to take the kids with you. And so I think that should be carved out. Thank you.
Thank you.
Anything else? Thank you, Ms. Mudge, for being here. Chair calls Sandra Aguilar. We'll note that Ms. Aguilar registered on behalf of herself for the bill but did not testify. Next, the chair calls Robert Garza. Mr. Garza, your affirmation shows that you're here on behalf of yourself and you are for the bill, correct?
Correct. Thank you for having me. My name is Robert Garza. This bill was born out of necessity after I drafted SB 718 last session with the support of Senator Paxton and Representative House Cook. It passed unanimously and was signed into law by the governor. When the false allegations stopped, my ex turned into interference with child custody. I took both the civil and criminal routes. That journey led me to this legislation. We would not need this bill if the current statute did not contain legal loopholes, but it does. And unless we provide clarity, prosecutors are left with nothing but grand jury bait, because they cannot pursue cases they cannot pursue because of vague and outdated language. This bill fixes that. It gives prosecutors the tools they need and law enforcement the authority to intervene. The three strikes model is structured, fair, and effective. It demonstrates a pattern of bad behavior while allowing parents the opportunity to correct it. It's not a state jail felony the first time, as it is now. Let me be clear. If you oppose the three strikes bill, you're against protective parents and do not understand it. By adding or subtracting any more language to this bill, it creates a space where you run contrary to the current family code. Another point to make, we are not addressing out-of-state or international cases. Those are already a state jail felony the first time that the parent interferes. So there's no need for that. There's already language in the bill. It complements the existing family code by reinforcing orders already issued by the court instead of making them go back to court to get more orders. This bill protects protective parents. It protects children from being caught in the middle. It respects both parents' bonds with their children and restores the liberty to parents without interference, manipulation, or fear. This bill applies, it's pretty self-evident.
Any questions for Mr. Garza? Okay. Thank you for being here.
Thank you.
We have George Saldana. George Saldana here. And your affirmation shows that you are George Saldana here on behalf of Interference with Child Custody Group Texas, and yourself, and you're neutral on the bill, correct?
Yes, sir. Can you give some copies?
Thank you, sir.
Do I start when
Go ahead,
when
yes,
you
sir.
finish? Okay. My name is George Saldana, and I'm going to go neutral on this bill. What I've given you is the Texas District and County Attorneys Association meeting we had here in Austin. Representative Richard Raymond set that up a few years ago, trying to go over interference with child custody. It's a state jail felony. We've met with DAs from across the state to have this enforced. Sorry, I'm out of breath. But as y'all know, this isn't getting enforced. I encourage you to talk to your DAs in your county to have this law enforced. Now, pertaining to the bill is going to amend the B portion of interference with child custody. The B portion talks about enticed or persuade the child to leave the state. The issue we're having is on the A portion. The A portion is takes or retains the child in violation of a court order. So while I believe this is a good step moving forward, what we're doing is we're gonna, and I hate to use the word limit, but we're gonna kind of limit the felony to a misdemeanor when another parent entices or persuades the child to leave the state. If we can't enforce these court orders on the state level because DAs are not taking this charge under the A subsection, how are we going to enforce the B subsection with the enticement or persuasion of the child to leave the state? I don't know how many of y'all have ever done a UCCJEA motion or a petition, right, to obtain a child. Was that my time limit?
Well, you got about 20 seconds.
Okay, I'm sorry.
Kind of
So the enticement and the persuasion, you can't really entice or persuade a child to leave the state until you actually have obtained the child. So if it's there a retention or a taking or a retention, then it's kind of, I don't want to say useless to try to modify the B portion, but giving it a misdemeanor 500 civil charge, okay, you're lowering it down from a felony. The reason it's a felony is because you need federal law enforcement to travel outside the state to obtain the children and bring them back.
We've got, Ms. Jones has a question.
Yes, ma'am.
I've got a question. So you said that the section, it's already too late because they actually would have them kidnap them or whatever before you get this. What would be your fix to that, if there was one?
Honestly, and in my experience working with parents that deal with this issue, the simple, most cost-effective solution is to have law enforcement mitigate the situation out in the field.
What does that mean?
When they mitigate the situation, they look at everything that's being presented at that scene. Is it hostile? Is it non-hostile? Right? If it's non-hostile and the dad has a valid judicial court order, why are we restricting their fundamental right to their child? And so with this, you're talking about enticing or persuading the child. And that's what this bill goes over. And it says to leave the state. So if a parent picks up their child and moves to New York, now the father has a hard time trying to enforce this order, much less enforce it here than in New York, because there's no jurisdiction. If you go into the history about interference with child custody, the reason it's a felony is because when it was adopted before the UCCJEA came out, the federal law. And so the UCCJEA, Uniform Child Custody Enforcement Jurisdiction Act, sorry, I ran over here. It was legislated after, I'm sorry, the history. It was legislated after the whole issue. Law enforcement didn't want to get involved with these issues So they kept saying it was a civil matter.
So most times, when something like that happens, when it's a child custody issue, law enforcement comes out there and they say, hey, you got to go to civil court. This is a civil matter, right? So I understand that, but I think that it's not always easily ascertainable what's happening at the scene, right? For example, if it's a domestic violence situation, then it could appear from the outside looking in like it's not hostile when I just got beat, right? And I'm afraid to say anything. And so when the police are out there, I don't say anything. So I think that's hard to figure out for police. But what I'm trying to figure out from you is, are you saying, I don't like this? I know you're neutral, but I don't like this because it doesn't allow the police to do something at that moment. And I think I think X is the remedy. Can you give us a remedy that you think would work?
Again, I believe when you mitigate the situation, we all have the presumption that we're innocent, and it's even in the family code. And if you look deep into the family code, interference with child custody is domestic violence under the title. Under the title it's under, there's a presumption there that it's domestic violence. So while we're trying to protect victims of domestic violence, it's also domestic violence to keep or retain the child.
And let me be clear, part of my practice is that I practice family law. And parental alienation is bad. Whether parents realize it or not, keeping your child from one of their parents, it's going to manifest itself eventually. The child might not be able to figure it out when the child is younger, but when they get older, trust me, your child's going to have issues. I was just trying to figure out what your fix is, and it seems to me you're saying that officers should be able to do more at the moment in time that they're called out, and that's your fix.
Well, the government code, the family code has a specific statute that says every court order must have, the legal, any peace officer of the state may use reasonable efforts. Reasonable efforts, and we talked to the Senate yesterday about contempt orders. Reasonable efforts are trying to mitigate the situation in the best interest of the child. And so while someone has claims of domestic violence, there are legal remedies they can use. They can use, and Harris County, I'm very familiar with Harris County. There's AVDA, there's other resources out there in which they can use to obtain the correct mechanism to take or retain the child legally.
So I think you answered my question. Thank you. And I would like to thank you for bringing up AVDA, which is Aid to Victims of Domestic Abuse. It's one of the organizations that I believe very strongly in. But thank you. I think you answered my question.
Thank you.
Thank you. Mr. Cook?
I just want to confirm, what part of this bill do you not like? I don't think this bill says what you're saying it says.
If I can read it, an offense under subsection B is a Class C misdemeanor punishable by a fine of $500. Right now, it's a felony. It's a felony because when you take a child out of state, that's an issue.
But that's the part that you keep saying out of state. It's not required that it be out of state.
It says at the
under this bill.
It says number 2, entices or persuades. I have the bill here if I can show you.
I've got it right in front of me.
It says number 2, enticed or persuades the child to leave the state.
What section?
Right above section 2. But that brings an important question. What about for people in state when they persuade or entice the child to leave the custody of the parent here in the state of Texas, whether it's Dallas, Houston, Fort Worth? I understand removing the felony when children are being taken over crossing the lines. I think the safeguards the constitutional safeguards to protect the child, you have a legal remedy in civil court and you have a legal remedy in criminal court. And your civil court's not going to go pull the other parent from New York to bring the child back for a $500 misdemeanor. So you need that felony bite. But again, if parents like myself are having a hard time because the other parent is retaining the child or taking the child in violation of the court order, here.
The point I'm making is that you can you're talking about the punishment, but I'm talking about the crime itself. does not require that the child be taken out of the state. What you're talking about is the punishment level goes up if the child is taken out of state, correct?
Well-
That's the point you're making, is that based on the way the bill is written, is that it takes, if the child goes out of state and it's on the first occasion, it's not a state jail felony like it is currently. That's the point you're making.
Currently, it's a felony.
That's what I just said.
Yes, sir.
Okay, thank you.
Okay, any other questions? Okay, thank you for being here.
And I'm sorry, I forgot my shirt and I was running late and there was a car accident.
You look great. Anyone else here to testify for, against, or on Senate Bill 2794? If not, Representative Dutton to close.
Thank you, Mr. Chairman and members. Let me just address two things, which the witness brought up. The witness that just left talked about out of state. I'm not sure what bill he was looking at because this bill doesn't have anything to do with out of state. I'm not sure what he was referencing, but the bill clearly states that it's about interfering with child custody by the non-custodial parent. And secondly, I would just call attention to the fact that under Section 2503 of the Penal Code, it reads that the subsection doesn't apply if the person was entitled to possession or access of the child and was fleeing the commission or attempted commission of family violence. That's already in the law. And so I'm not sure what the other witness was referencing either, because the family violence exception is already there.
Okay, any other questions for Mr. Dutton? Ms. Jones?
Can you cite that section, please? About
Section
the one that
25
talks about the family violence.
Section 2503, Section C2.
You said that's all, you said that.
That's already in the law.
Okay.
Yeah. Yeah, C-22. It's in the law.
Okay, thank you.
Yeah.
Okay, thank you very much.
Thank you,
Ms.
Mr.
Dutton,
Chairman,
if
members.
there's nothing else, the chair will leave House Bill 2794 pending. Mr. Harris, let me get Ms. Harris-Davila on real quick, because she's just got one witness. Chair lays out Senate Bill 2017 and recognizes Representative Harris-Davila.
Thank you, Mr. Chairman and members, for the opportunity to lay out Senate Bill 2017 before you today. Street racing and reckless driving was addressed by the legislature in the 88th regular session with the passage of HB 2899 and HB 1442. However, current statute doesn't address burnouts and wheelies and leaves law enforcement with limited tools to deter this behavior. SB 2017 creates a criminal penalty for intentional performance of burnouts and wheelies in motor vehicles. The proposed penalty would make this offense a Class C misdemeanor, and I'll just close with noting that one of the reasons why we haven't needed legislation on this before is we're just seeing an increase in street racing and this type of behavior probably in the past 7 years, and part of that is videos on TikTok, and you get a lot of value out of the shock of the actions that you do, and so that's why we're presenting this legislation. I'm happy to answer any questions, and with that, I close.
Any questions?
Or
members?
respectfully reserve my right to close, I should
Well,
say.
and certainly. Thank you. Oh, Ms. Bowers?
Thank you, Representative. Thank you, Mr. Chairman, as well. I think that I think in the last couple of previous sessions, we've seen a little bit of this before. So you said in the last 7 years, right?
Yeah.
Okay, so thank you for bringing this to our attention and bringing this to the legislature.
Thank you.
Okay, well, we have a witness we'll call and then
Perfect.
allow you to close.
Thank
The
you.
chair recognizes Bruce James, or calls Bruce James. James, how are you? Your affirmation shows that you are here on behalf of the Texas Department of Public Safety, neutral on the bill, correct?
Yes, sir.
Thank you for being here.
Well, good morning, Mr. Chairman, members. My name is Bruce James. I'm Assistant Chief with the Texas Highway Patrol. Here as a resource witness if you have any questions for me.
Okay, Mr. Burdell?
What's the current, oh, sorry. Oh, yeah, I'm Verdell here, present also.
Oh, I recognize Representative Burdell here. present, okay?
Thank you, appreciate it. What's the current crime for doing a wheelie or a burnout or something like that?
Currently, there's not one, unless you can ratchet it up to a reckless driving charge, which would be a Class B misdemeanor. But that would be, but just for doing a wheelie or burnout, there's nothing in statute at the moment.
So I can do wheelies right now and get away with it? Is that the, okay, all right.
Now, there are city ordinances, a lot of the cities do have ordinances for that.
Okay.
But as far as statewide, no, sir.
Okay, thank you, appreciate it.
You're welcome.
Mr. Money?
Earlier this week, or I guess over the weekend, I was on Congress Avenue, and there was a guy on a motorcycle just driving a wheelie. I mean, for like blocks and blocks. It was pretty impressive. But so my question is, I mean, that I think is pretty clearly intentional. He didn't look like he was in distress or didn't know how to stop it. But what? How are you going to have problems with enforcement when it says may not intentionally break traction to spin a tire? So, I mean, isn't it kind of presumed that if you're spinning tires, you're doing it on purpose and not how to, how?
Yes, sir, for the most part, yes.
Yeah, I mean, I would think so. I mean, does that create any kind of barrier to investigation or prosecution where you have to prove intentional in the guide?
No, I don't believe so, but, because there's going to be those situations where there may be something that's accidental. You have a new driver or something that's not used to the
Doesn't know how
vehicle,
to
may
engage
break
the
traction,
clutch.
so that gives a little bit of, we always give our troopers, discretion on that anyway, so.
Okay.
But I don't think it would be an issue, no, sir.
All right.
Okay.
That's it.
Thank you. Any other questions? If not, appreciate you being here.
Yes, sir, thank you.
Anyone else here to testify for or against or on Senate Bill 2017? If not, the chair recognizes Ms. Harris-Davila to close.
Thank you. Unless anybody has more questions, I close.
Any questions, members? Yes.
Can you
Mr.
ride a
Bell.
wheelie?
I can't, not yet.
And
Thank
the other
you.
question is, how do you expect senior citizens to have any fun?
Yes, that's me, no fun.
Okay. I know.
Thank
Okay,
you all.
Okay, if there's no other questions, the chair will leave Senate Bill 2017 pending. Chair lays out House Bill, Senate Bill 993 and recognizes Representative Harris.
Thank you, Mr. Chairman and members. Senate Bill 993 authorizes peace officers with the Comptroller's Criminal Investigation Division to apply directly to a district court for a warrant to install and use mobile tracking devices. The CID is responsible for enforcing state tax laws and preventing tax fraud, including motor fuel theft. These crimes often involve organized schemes where fuel is stolen, transported, and resold illegally. Mobile tracking devices help law enforcement monitor suspect vehicles and pinpoint the locations where these illegal activities occur. Under current law, CID officers are not authorized to apply for these warrants on their own and must rely on other local and state law enforcement agencies to do so on their behalf. This creates delays, burdens other agencies with additional work and can weaken warrant applications. By granting CID officers the authority to apply for tracking device warrants directly, Senate Bill 993 streamlines investigations, preserves valuable law enforcement resources, and ensures stronger, more informed applications are presented to the court. I believe this bill, we passed it last session out of the House and it got bogged down in the Senate. But with that, happy to answer any questions, would request my right to close.
Certainly. Any questions for Mr. Harris? Okay. Thanks. We'll go ahead and call our witnesses. Well, I'm sorry. Mr. Riddell.
If I understand currently, they have to go through DPS to get the warrant, is that correct?
It can be local law enforcement as well, but that's typically they would go through DPS.
Okay, and then this would say that they can basically just go through a
directly
judge
to the
and-
district court. Yeah,
Okay,
that's
roger
right.
that. All right, thanks.
Okay, anything else? Okay, we'll recognize you to close. And we have, the chair calls Brett Froh on behalf of the Texas Comptroller of Public Accounts. Your affirmation shows you're testifying neutral on the bill, correct?
That's correct, Chairman. Chairman and members, thank you for letting me be here. Lieutenant Brett Furrow with the Texas Comptroller's Criminal Investigation Division. This bill would definitely, it's not going to expand our current authority. We already get tracker warrants, but we have to go to another agency to request assistance. It does not include us in the wiretap part of that either, so it's not expanding our authority. We currently work a lot of motor fuel theft cases, motor fuel cases. You've seen some bills related to some of the stuff along the border. related to motor fuel being transported from one part of the state to another that's for export. This fuel is supposed to be being exported to Mexico, has some cartel involvement, and is very, very intensive time. Takes a lot of our time to go out and follow these, a lot of manpower. We also work a lot of motor fuel theft in the Austin and other metro areas and rural areas related to fuel that's being stolen using stolen credit card information from skimmers on gas pumps, pulser tampering, any kind of fuel theft. Those kind of suspects a lot of times will drive pickup trucks and vans and haul large quantities of fuel, anywhere from 100 to 2,000 gallons of fuel, and they drive very erratically, not safe. They speed up, they slow down, they take exits quickly, they run red lights. They may be in the far left lane and cut across 3 lanes of traffic to take an exit. They're doing that to see if there's any counter surveillance. That's their counter surveillance mechanism, to see if anybody's following them. With that, if y'all have any questions, I'd be happy to answer any questions.
Any questions, Mr. Riddell?
Sorry, I'm just full of questions today. It'd be safe to say that if you had to go through an agency waiting on them to get it done, then you would end up possibly losing the person that you're trying to tell at that moment.
That is correct. Yes,
This
sir,
would
we
give you
would.
quicker access to do that. So.
It would speed it up a lot, yes, sir. A lot of times we do end up losing those suspects and vehicles because it takes so much time to get a warrant through another agency.
All right, thank you, appreciate it.
Yes, sir, thank you.
Thank you for being here.
Thank you.
Appreciate it.
Thank
Chair calls Justin Scott. Mr. Scott, your affirmation shows you're here on behalf of the Texas Comptroller of Public Accounts testifying neutral on the bill, correct?
Yes, sir. Justin Scott, Chief Director of Law Enforcement for the Texas Comptroller's Office, just here to answer any other questions that you may have, the committee may have of us related to this bill. One thing that I do want to add, that this adds an additional means of officer safety to my teams that are across the state following these vehicles and not compromising their safety or the other motoring public as well. Thank you.
Any other questions? Okay, thank you for being here, Mr. Scott.
Thank you,
Is there
Mr.
anyone else here to testify for, against, or on Senate Bill 993? If not, the chair recognizes Representative Harris to close.
Thank you, Mr. Chairman. Members, I close the request favorable consideration.
Okay, thank you. Any questions, members? If not, the chair will leave Senate Bill 993 pending for now. Mr. Little, you want to go with yours? The chair would recognize Representative Little to lay out and explain Senate Bill 826.
Thank you, Chairman Smithy. Thank you, members of the committee. Senate Bill 826, you get a DWI in a school zone while the light's flashing or while kids are in school and you're subject to the slow down period, you get a state jail felony. I respectfully reserve the right to close.
Okay, showing no witnesses have signed up, is there anyone here to testify for, against, or on Senate Bill 826? If not, Representative Little.
826.
Oh, I'm so
826, yeah.
I had the wrong one.
Senate Bill.
It's okay, sir.
Senate Bill 826. Anyone here to testify? If not, Representative Little to close.
I close. If anyone has any questions, I'm happy to answer.
Okay, any questions, members? Okay, if not, the chair will leave Senate Bill 826 pending for now. And let's see, we've got Mr. Cook. The chair recognize. Okay, the chair recognizes Representative Cook to lay out and explain Senate Bill 957.
Thank you, Mr. Chairman. Members, we all know that human trafficking is a global crisis impacting millions of people annually, including adults and children who are subjected to forced labor, sexual exploitation, and other forms of modern-day slavery. Traffickers often force their victims to perform commercial sex acts, otherwise known as prostitution, and repeatedly sell their victims against their will. Traffickers are commonly detained by law enforcement, released on bail because their finances are unknown or hidden, and return to selling their victims within days. Prosecutors have expressed concern that under current law, they must choose a specific date and prove the instance of 2 or more offenses on that date. Senate Bill 957 would allow the jury access to important evidence of a trafficker's recruitment, management, and financing of their criminal operation over a period of time. Current law provides a snapshot of a specific date and time. A broader view is needed in order to encapsulate the scope of a trafficker's enterprise. Senate Bill 957 creates the first-degree felony of continuous aggravated promotion of prostitution and defines the offenses as engaging in 2 or more times in aggravated promotion of prostitution, Section 43.04 of the Penal Code, during a 30-plus day period. This bill applies to individuals who operate or manage a prostitution enterprise involving 2 or more victims over a period of 30 days or more. The bill permits a jury to convict without unanimous agreement on specific dates or dates, so long as the jurors agree that the crime occurred over the required time frame. Additionally, Senate Bill 967 does not require a prosecutor to prove force, fraud, or coercion as required under the continuous human trafficking statute. This bill aims to protect vulnerable populations and hold traffickers accountable for this heinous criminal activity. Appreciate the opportunity to lay out Senate Bill 957, and Mr. Chairman, I'd like an opportunity to close when appropriate, and would be happy to answer any questions.
Okay, we have any questions for Mr. Cook? If not, our witness, we have the chair calls Lauren Lawrence. And your affirmation shows, Ms. Lawrence, that you're testifying on behalf of Phil Sorrells, the Travis County District Attorney.
Tarrant County.
I'm sorry, Tarrant County. There's a big difference between Tarrant and
Yes,
Travis
sir.
County. Okay. The Tarrant County Criminal District Attorney, and you are for the bill, correct?
That is correct, Chairman Smithy, and I am simply here to answer any questions that the committee might have.
Okay. Any questions, members? Yes, Mr. Burdell.
What's the current penalty for someone doing what's it called, a continuous aggravated promotion?
So the offense of continuous aggravated promotion currently does not exist. The underlying offense of aggravated promotion of prostitution is a first-degree felony with a punishment range of a standard first degree, so 5 to 99 years or life. This would also be a first-degree felony, but it would enhance the minimum punishment to 25 years.
Okay, thank you, appreciate it.
Okay. Any other questions? Okay, appreciate you. Oh, I'm sorry, Mr. Burdell.
So you're saying if somebody participates in this, minimum confinement's 25 years on it if this passes?
That is correct.
Okay. What is it on just aggravated promotion? What's the minimum?
5.
5. Okay, thank you.
All right. Thank you for being here.
Thank you.
Anyone else here to testify for or against or on Senate Bill 957? If not, the chair recognizes Representative Cook to close.
I close, Chairman.
Okay. And so with that, the chair will leave Senate Bill 957 pending for now, and the chair recognizes, the chair recognizes Representative Cook.
You need to lay out the next bill first.
I'm sorry.
Lay out the next bill.
Okay. The chair recognizes Representative Cook to lay out and explain Senate Bill 872.
Thank you, Chairman Smithy. Members, under Section 30.04 of the Penal Code, the criminal penalty for burglary of a vehicle can range from a Class A misdemeanor to a third-degree felony currently, depending on various factors such as criminal history and type of vehicle. Under current law, the only vehicle of a burglary offense in which specific items are listed in a burglary of a wholesale distributor with intent to steal a controlled substance. No other items as specifically mentioned within this section of code, leaving a gap in the law for other potentially dangerous items. Currently, theft of a firearm from a vehicle is classified as a Class A misdemeanor, essentially treating this theft equal to the theft of innocuous items like clothing, stereos, cell phones, etc. And we all know that is not the same thing as someone stealing a firearm. Over the past decade, the trend of firearm thefts from vehicles has grown exponentially. The ATF has linked car burglaries in San Antonio to weapon trafficking, notably seizing more than 200 stolen guns just in the month of August of 2024. Additionally, the city of Houston reported over 3,000 firearm thefts from vehicles in the year 2022. Senate Bill 872 aims to close a gap in the law by creating a third-degree felony offense of theft of a firearm during the burglary of a vehicle. Appreciate the opportunity to lay this bill out. Happy to answer any questions and would like an opportunity to close when appropriate.
Okay. Any questions, Mr. Cook? Mr. Burdell?
I'm just on a roll today, sorry. The, it's a federal felony right now if you steal a firearm, is that correct?
Yes.
What's the punishment for that?
I don't know.
Okay, I'm just curious if this is matching the federal or not. Okay, all right, thank you.
Thank you.
Okay. Mr. Money?
Didn't we have an HB that was similar to this about a month ago?
Yeah, there's been several burglary vehicles, and there was one specifically here.
Yeah, and I guess it just didn't go anywhere, or didn't. Okay. All right. No, I think it's good. I liked it then, I like it now. All right.
Thank you.
Okay. Any other questions? If not, we have a, I'm sure, no. Okay. Okay. Is there anyone here to testify for, against, or on Senate Bill 872? If not, the chair recognizes Representative Cook to close.
I close, Chairman.
Okay. And so the chair, if there's no objection, will leave Senate Bill 872 pending. Chair lays out Senate Bill 16, or recognizes Representative Cook to lay out and explain Senate Bill 1660.
Thank you, Chairman Smithy. This Senate Bill 1660 is by Senator Huffman. I appreciate the opportunity to lay it out. Under current law, there is ambiguity regarding when toxicological evidence can be destroyed, especially in cases where the retention period has expired. Updating the statute related to this type of evidence to reflect modern needs and capabilities will reduce storage costs and administrative overhead, freeing up resources to better preserve critical evidence. Senate Bill 1660 requires that crime laboratories annually notify the relevant prosecutors' offices about their possession of these types of evidence related to alleged offenses within that county. This notice must also include the date the evidence was received and must be made by hand delivery, certified mail, or email to an address designated by the prosecutor's office. Additionally, if the prosecutor's office does not use a written denial within 90 days of receiving a request to destroy evidence and the applicable retention period has expired, the entity storing the evidence may proceed with its destruction. These provisions apply only to evidence for which the retention and preservation period expires on or after the effective date of the bill. These updates set clear guidelines for managing toxicological evidence and ensuring proper communication with prosecutors while balancing evidence, retention, and timely disposal. Would be glad to answer any questions. Would like an opportunity to close when appropriate,
Okay.
Mr. Chairman.
Any questions for Mr. Cook? If not,
Ms. Jones.
Ms. Jones.
Talk to me, Chair Cook, just about you can destroy the evidence. When, did you say something about destroying the evidence?
Yes, so basically, a notice is sent to the prosecutor's office, and if there's not a written denial, if the prosecutor's office does not issue a written denial within 90 days, then it can be destroyed. So, and that notice has to be either hand-delivered, certified mail, or to an email address that's been designated by the prosecutor's office.
I just want to make sure I understand this. So if the DA's office accidentally, inadvertently, or is like worked a lot and they miss sending something, then evidence in a case can be destroyed? Is that what that bill is saying?
That's, yeah, with regard to toxicology, yes.
So what happens if somebody decides they want to appeal? That evidence is gone because if I were the DA, I just would never send any notification, and then all the evidence can be destroyed. Could that happen?
Could what happen?
Could toxicology evidence be destroyed if the DA just doesn't send annual notifications? Because I think that is a problem.
If who doesn't send it out?
The prosecution.
They're receiving the notice. Yeah, so this
From
the labs.
So if an overworked lab doesn't send a notice,
then this bill is not invoked. This bill is only invoked if so basically it's a storage issue. And so if the storage facility gives the proper notice as required by hand delivery, certified mail, or email to the DA's office, the DA's office has 90 days to say whether or not they want it to be retained. And if they don't respond, if the DA's office doesn't respond, then it can be destroyed after that.
so after the lab sends a notice to the DA's office saying, hey, we have these toxicology reports and evidence, if the DA's office does not, within 90 days, say, hey, keep it or something, then the lab can destroy the evidence.
Correct.
Why would not... So this terrifies me, by the way, which is why I'm asking the questions, because what if within 90 days as a defendant, I have toxicology evidence against me. I have to rely on the DA's office to retain evidence for me, otherwise it's destroyed. What if I don't know this? I literally may lose the ability to have a legitimate fight if I decided to appeal. Do you understand my question?
I understand it. I mean, I think that's why the notice is, I believe that in the bill, that's why it's set out with specifics. It's not, you can't just mail a notice. You have to do it by certified mail, which means someone is acknowledging from the DA's office. It's hand delivery, certified mail, by email. I mean, so there are good forms of delivery to make sure the DA's office is placed on notice.
But I guess my concern is, why is the defendant or the defendant's lawyer not notified? Because the toxicology may very well be the only way to prove, give me a chance to win on appeal. So somebody who doesn't represent me as a defendant or myself has no notice that there's evidence that could be destroyed. And I think that's a huge problem for me. Like, why are we notifying the DA? If I were the DA and I didn't want any evidence to be retained, I don't know why, I just wouldn't respond. And then the defendant doesn't have a right or doesn't have anything to go back and retest to see if the DA was wrong or whatever. So that's my concern.
Yeah, okay, thank you.
Thanks.
Okay. Any other questions? Okay. We'll reserve the right to close, and
Thank you.
the chair calls Brady Mills. And your affirmation shows you're Brady Mills on behalf of Texas DPS Crime Laboratory, neutral on the bill, correct?
Yes, Mr. Chairman.
And one other housekeeping measure, I show two it's recorded twice. Can the clerk have permission to delete one of those?
Yes, sir, that is correct.
Okay, so one has you as division chief, and the other has you as crime laboratory director. Which one do you think you would like to keep, and which one delete?
Division chief would be fine.
Keep division chief. Okay.
Yes, sir.
Thank you.
Yeah, sorry for the
that.
confusion.
Okay.
The office must have registered me as well. Brady Mills, the chief of the Crime Laboratory Division for Texas Department of Public Safety, as a resource on the bill, if there's any questions.
Okay. Any questions, members? Yes, Mr. Riddell.
I do have one question. I was thinking the same thing Representative Jones was thinking. Is there, because it may be somewhere else, is there a requirement to let the defendant know that is going to be destroyed?
Yes, sir. There is a notification piece, and there's also a timeline. So this bill does not change the storage timeline. So it's either 2 years or statute of limitations where the evidence is kept. And so the discussion between the laboratories storing the evidence and the prosecutors are after that fact.
Okay, then the defendant or the defendant's representation would still have some kind of way to fight this from being destroyed if it was. Is that
There
possible?
would be notification in a process, yes.
Okay, roger that. Thank you.
Okay, Ms. Jones has a question.
So in my dealings with DPS, I have a client who's charged with a crime. It's we don't send anything off to the lab. The state has the evidence and they send it off to the lab. And we actually don't get anything until the prosecution gives us stuff. Like, we could be waiting for a long time for results. So we're just basically waiting. And even when I contact the DA's office and like, hey, is the lab back? Is the lab back? The DA's like, well, we hadn't gotten it back. So we literally have to rely on whether the DA actually gives us the lab. So what concerns me about this bill, there is no notification to the defense. And you said there was a notification. I'd like to know what the notification is, where we, the defense bar, gets notified from DPS that you have something, because we get all of our information from the DA's office. And if DPS sends a notice to DPS, if the lab sends notice to the prosecutor and the prosecutor doesn't respond, we literally wouldn't know. The defense bar wouldn't know. So, I mean, I'm like I say, I'm really struggling with this, because the one person who should decide whether the evidence is destroyed is the person that the evidence is being used against, or that could potentially exculpate the defendant. And so this still doesn't resolve that problem. And again, if you can show me where I'm supposed to get notice, because then I guess I need to go as a defense lawyer and go and say, hey, why DPS are you not notifying me about things related to my client?
I think the first piece is the reporting that we do. So the reports that we do on the results of the testing is what you first referenced, that's going to the DA's office and the investigators, and then they would give those to the defense counsel. The notification piece is after the evidence has reached the timeline for storage and is post-testing. And so that's where the notification of the destruction event occurs.
Right, but that notification is going to the DA's office. That notification is not going to the defense.
I believe in another piece of statute, within existing statute, there is a notification between the prosecutors and the defense to allow them to notify or to understand that there is a destruction event occurring.
What I'm saying to you is what generally happens, at least in my experience, is after someone is pled, they have these form sheets that say, oh, by the way, within 90 days, we're going to destroy evidence in your case, which I believe we've had a bill this session to try to remedy that, because in some places it was like they wouldn't offer you the plea if you didn't agree to allow evidence to be destroyed in your case, which I believe to be a problem. But there is no notification to us. I'm just letting you know that. We have to totally depend on the prosecution to tell us what's going on. Even in cases where we know that there's a lab and we're requesting a lab, there's always an excuse for why we didn't get it. So I'm telling you that I think this is not good constitutional policy, but thank you. Okay. And I understand your problem that you're having storage issues, but it shouldn't err on the side of destroying evidence against an accused, because the Constitution provides you with certain inalienable rights, and the right to cross-examine witnesses and due process are all very important. And I think that this flies in the face of that, but thank you.
Any other questions? Thank you for being here, Mr.
Thank you, Mr. Chairman.
And is there anyone else here to testify for or against or on Senate Bill 1660? Seeing no one, Chair recognizes Representative Cook to close.
Thank you, Chairman. And lastly, but I think what I would say is and I'll be happy to reach out and try to work with Representative Jones' office with regard to this bill. But this bill only deals with the notification issue, and so it's not changing any current law. It's not a constitutional matter. This is Code of Criminal Procedure, and it's simply a notice provision within a statute. And so with regard to any notification and the timeline, I would like to work with Vice Chair Jones offline. I know we have other bills today, but I'll make sure that I get those statutes together and meet with you to discuss those.
And I'm happy to meet with you, but this is a huge issue. So of course I will work with you offline, but the very person who needs to be told that they're going to destroy evidence is the person who doesn't get notification.
If that's the issue, I mean, if it's such a huge issue, then why didn't you, as a 30-year defense lawyer and as a member of this body, I mean, why haven't you brought a law, some type of revision to the law? I mean, it's such a huge issue. You've been here 2 sessions, and I've never heard you talk about this issue.
Right, because it didn't come up until this bill. And
No, this does not change. This is just a notification. This does not change the current process or the timeline.
But respectfully, there are a million bills that go on in this session, and I deal with them as they come before the committees. I don't know about you. I'm not a chair. I don't have staff to go through every single bill and watch every single bill. But when they come before criminal jurisprudence, then I'm going to do that. And I'm letting you know that now before it gets out of here, before it gets out of this committee, that destroying evidence that could potentially exculpate a defendant is a problem. And
But it's already
so
being done.
all I'm saying is I hear you say that a lot, is why didn't you see this before? But you see it when you see it, and you deal with it when you deal with it.
No, I'm just saying, you said it's such a huge issue. I'm just like, this process is already in place. This simply changes the notification process. That's all this bill does.
Right, but we had a bill earlier that came here where we talked about it, myself and Rep. Little, about destroying evidence. People don't think about it. I mean, they just sort of don't think about it until it impacts them. So now I'm on notice of it, and I'm happy to work with you about it. But I will say again that destroying evidence without notice to the person that the evidence could hurt or help is constitutional.
So we'll let y'all
Respectfully disagree, but yes, we'll work offline, Chairman.
Okay. Any other questions for Mr. Cook? If not, oh yes, Mr. Riddell.
Representative Cook, I think just on page 1, between line 15 and 16, I think we could just add in as an amendment number 3, saying that you also must notify the defense or the defendant or the defendant's representation, that would make sense and probably solve that concern. So just wanted to point that out. Thank you.
Thank you, sir.
Okay. If no other questions, the chair will leave Senate Bill 1660 pending. Mr. Anchia, are you ready? Okay. The chair. Have we done it? Okay. The chair lays out Senate Bill 2611 and recognizes Representative Anchia.
Thank you, Mr. Chairman and members. And I'll try to be brief given the time before the floor. When I oftentimes come to this committee, it is to address deed fraud, and that is no different with this bill. Senator West and I have been working with our Dallas County District Attorney's Office extensively on this. We've dealt in other policy areas with the clerk's process and the filing. We've dealt with the notary process and increasing penalties for notaries who don't actually witness the signatures and conduct fraud. Also dealt with the Secretary of State's training. This bill seeks to get at a different part of the problem, Mr. Chairman. And as this committee has heard before, it's a very serious problem. This legislation addresses many of the concerns discussed during the interim charge that you all are well aware of, that ensures security and protection of Texas property for all people. Now, I'm going to give you a reference point just from popular culture, because earlier in 2024, you may have heard about this, when a fraudulent investment and lending company attempted to seize Graceland. I don't know if you followed this. You heard about it, right? Right. So this is not new information for some of you. This is obviously the legendary Memphis home of Elvis Presley, and they did so by forging documents and falsely claiming the property had been used as collateral by one of the Presley daughters on a defaulted $3.8 million loan. They nearly succeeded, despite the notoriety of the property itself, despite the wealth of the family and the notoriety of the family. It almost worked. Had the Presley family not had the legal and financial means to fight back in court, Graceland might have just been stolen. And while Graceland grabbed national headlines, the truth is that thousands of properties right here in Texas are subject to similar schemes of real estate theft and fraud. And under Texas law, the theft of real property is not clearly distinguished from the theft of personal items like a handbag or a wallet. And when those things were reported to entities like the Office of Court Administration, or OCA, or the Department of Public Safety, they lack the distinction, and it can hinder law enforcement's ability to track trends, allocate resources, and most importantly, deliver justice for the victims. So Senate Bill 2611 is a common sense, nuts and bolts solution to a very real and urgent problem. The bill, and I'll give you the top lines, it insulates property owners from bad actors by strengthening the legal safeguards available to them. It enhances investigative tools for law enforcement and prosecutors, and it provides meaningful remedies to victims. Currently, you get your property stolen, and via deed fraud, it is very difficult, A, to recover that property, and then B, to actually clear your title. There are titles out there that have, for properties that have actually been recouped by the rightful owner that still show a cloud on the title. And so, members, this is a comprehensive bill. I would ask, given the time constraints that we have some people, victims, members of District Attorney's Office who are going to testify, clerks who are going to testify about this issue. And with that, I just ask for the opportunity to answer questions if you recognize me to close.
Okay, certainly. Any questions for Mr. Anchia? Okay, we'll recognize
Thank you,
to
Mr.
close.
Chairman.
Chair calls Robert Brown. Mr. Brown, your affirmation shows you testifying on behalf of yourself and as chairman of the board of First Christian Church, Lancaster, Texas, and you're for the bill, correct?
Yes, sir.
Okay.
My name is Robert Brown. I am the chairman of the board of the First Christian Church of Lancaster, Texas, which was the victim of a deed fraud theft, and I am testifying in support of Senate Bill 2611. This has been a nightmare of frustration. It's all I can say, an utter nightmare. In early May 2019, our church received letters from the Dallas Central Appraisal District inquiring about the sale price of our 2 parcels of adjoining church property. This came as an absolute shock to us as we had not sold any of our property. As board chairman, I immediately began gathering information from the Dallas County Appraisal District on our properties. I found that quitclaim deeds had been filed with the Dallas County Clerk's Office stating that our properties were purportedly sold to a pastor and his church. I immediately went to the county clerk's office and obtained copies of these quitclaim deeds, which were fraudulent in every respect. These fraudulent documents listed names of individuals who were in no wise known to any of our congregation nor members of our congregation. Absolutely no corroborating evidence was required to be provided to the Dallas County Clerk that the individuals listed on these documents were truly representative of our church and our congregation and had the authority to act in the interests of the First Christian Church of Lancaster, Texas. This is where the frustration began. I immediately consulted the attorney who represented the Christian Church Disciples of Christ Regional Office of North Texas, who resided in Rockwall.
If you could kind of wrap it up, we're going to have to get out of here pretty soon.
Okay.
So if you could just kind of wrap up.
All right.
Okay.
It took us 2 years to get the titles of the church back in our name. Affidavits of fact were filed to no avail. The first attorney wanted to do civil claims on it. He'd already prosecuted this perpetrator before.
Yeah.
All right. Finally, with a local attorney in town, we're able to use government code 51.903, and it took 2 years using that to get it resolved.
Okay.
And then it took another, until from 2021 until last May, that the perpetrator finally got convicted in court.
Okay. Any questions? Mr. Verdell?
Just one quick one. You might have answered. I missed it. How much did it cost y'all to redo that?
We were fortunate. The first attorney wanted to file a civil lawsuit, and that was going to cost us $1,000 minimum. Mm-hmm. We don't have that kind of money. We're a small church. The second attorney that was in town worked for us pro bono. He was a friend of our organist, and he was able to get it resolved using the government code.
Okay.
So we're very thankful to him.
Thank you. Appreciate that.
Glad that it worked out okay. So any other questions for Mr. Brown? Thank you for being here, Mr. Brown. The
Thank
chair
you.
calls Jennifer Fogg. And Ms. Fogg, your affirmation shows that you're here on behalf of yourself and the County and District Attorneys, County and District Clerks Association of Texas, and you are for the bill, correct?
That is correct. My name is Jennifer Fogg, Chairman, committee members. Thank you for allowing me the opportunity to be here. And in respect of your time, I will keep this short. I am in support of this bill, and I appreciate your considering this bill, And I do want to say that this is a common sense bill, just like Representative Anchia said. And I would be happy to answer any questions that you may have.
Any questions for Ms. Fogg, members? Okay. Thank you for being here.
Thank you.
The chair calls Philip Clark. And Mr. Clark, your affirmation shows that you are Philip Clark testifying on behalf of the Dallas County District Attorney's Office for the bill, correct?
That is correct. Okay. Good morning. My name is Philip Clark. I'm the Assistant District Attorney for the Dallas County DA's office. And I am here in support of the bill, and I want to thank Representative Anchia. Thank you. I want to thank Representative Anchia and Senator West for bringing this bill. I prosecute many, many cases related to real property theft. And I have been part of the team that has crafted the language before you in this bill. I'm providing to you a handout with photos of a sampling of properties that have been the subject of this crime. you'll see a wide variety of properties there, from land to very nice homes to very depressed homes. This crime can happen to any kind of property. It can happen to any kind of homeowner. It can happen to retail properties and corporations. The bill is expansive and covers a lot of areas. I welcome any questions that you may have on what I'm calling a soup to nuts effort to address this growing problem. And it is a huge problem. To address the question over here, I have heard from victims whose attorneys have spent dozens and hundreds of hours trying to clean up on the litigation side, trying to clean this up. It is intractable. It takes years. More than just the money and the time, it's also immensely stressful to someone whose home, their nest egg, has been stolen from them. With that, I'm happy to address any questions that you may have.
Mr. Verdell?
One quick question. Are they targeting properties that have debt on them, or are they looking for properties with no debt associated with it?
I see both.
Okay.
I see both.
Roger that.
I do think that the lists of foreclosures are a source of information. Those are often targeted, but I see there's no rhyme or
It's
reason.
irrelevant. All right, thank you. Appreciate it.
It's terrible. It is a problem, for sure. Thank you for calling our attention to it. Any questions? Thank you, Mr. Clark, for being here.
Thank you.
Anyone else here to testify for, against, or on Senate Bill 2611? If not, the chair recognizes Mr. Anchia to close.
Thank you, members. I'll just, again, give you a couple of additional top lines. 10-year statute of limitations for real estate theft and fraud. That's really important. These cases take a long time, first to be discovered and then to be prosecuted. Number two, for those in the title business, I know this is important. This allows there to be the prosecution to be placed in the title records, and it would sit on top of the actual fraudulent document, so the people can see in the chain of title how that's been resolved. And then finally, it requires restitution. So members, with that, I close, and thank you for your time this morning.
Okay. Any questions for Mr. Anchia? If not, we'll leave Senate Bill 2611 pending. The chair recognizes Chair lays out Senate Bill 456 and recognizes Representative Lopez.
Good morning, Chairman and members. Thank you for the opportunity to lay out SB 456. Previously, organ trafficking accounted for up to 10% of organ transplants performed around the world. There is a sickening and booming industry of profiting from human organ sale. It is estimated that between $840 million to $1.7 billion is earned annually through organ trafficking. Our state is a proud leader in law enforcement and trafficking organized crime, but have left the evil practice of organ trafficking room to grow. Individuals have reported being misled, coerced, or otherwise forced into selling their organs. Through our research, stronger penalties for this action have effectively deterred the crime in other states. Currently, the offense of purchasing or selling human organs is classified as a Class A misdemeanor. Examples of Class A misdemeanor in Texas include criminal trespass, online impersonation, perjury, and violating a protective order. These crimes pale in comparison to the detrimental impact of human organ trafficking. SB 456 revokes a physician's license for using a harvested organ during a procedure and increases the criminal penalty for purchasing or selling human organs from a Class A misdemeanor to a state jail felony. Chairman, thank you for this hearing today, and I've been working with Senator Mace Middleton on this bill, so I thank you for this opportunity and request the right to close. And we do have a witness.
Certainly, we do have one witness. Any questions for Ms. Lopez? If not, the chair will call Jeslyn Hun. Sorry. How do you pronounce your last name?
Jaslyn Huynh.
Huynh. Okay, so your affirmation shows that you are Jeslyn Huynh, and you're here on behalf of combating global organ trafficking, and you are for the bill, correct?
Yes, correct. Good morning, legislators. I'm Dr. Jaslyn Huynh, a professor of criminal justice and also executive director of the Combating Global Organ Trafficking Organizations. And I'm here to fully support the Senate Bill 456. Human organ trafficking has become a major concern. Legally available organs for transplants accommodates roughly 10% of the demand. The shortage in organ supply currently means a recipient is added to a waiting list for an organ every 10 minutes. And on average, 20 patients die every day in the U.S. while waiting for a matched organs. And due to the high demand and supply for human organs, yearly, organ trafficking prevails as one of the most profitable crimes with an estimated $1.7 billion from roughly 12,000 illegal transplants. And the human organ trafficking network, which involves brokers, scientists, medical personnel, and hospitals, is prospering. According to the Health Department and Services, as of 2023, approximately 100,000 patients in the U.S. waiting for an organ, while only 16,000 organs donated from both living and deceased donors. Nearly 42,000 organ transplants performed that year. So the big question is, where is 28,000 illegal organs come from? Or in other words, 62% of organs come from the black market. So Houston is a major hub for human trafficking, including organ trafficking, while the victims, it still remains unknown. So it's time for us as policymakers, the lawmakers, law enforcement agency, and also community residents to link arms against this crime. And the trafficking in human organs must be prohibited and criminalized.
Okay,
So,
thank you.
Thank you for your
And so
time.
this bill would increase the penalty.
Correct.
Okay, commensurate. Okay, any questions, members? Okay, thank you for being here.
I
Ms. Wa-
appreciate for your valuable time. Thank you.
Anyone else here to testify for or against or on Senate Bill 456? If not, the chair recognizes Representative Lopez to close.
Thank you, Chairman and members. I ask for your favorable consideration of Senate Bill 456, as this crime targets the most vulnerable and low income, which are exploited and found online, as well as coerced. Thank you very much.
Okay, thank you. Any questions? If not, the chair will leave Senate Bill 456 pending, and the chair would lay out Senate Bill 442 and recognize Representative Fairley.
Good morning. Thank you, Chairman. Members, this bill, Senate Bill 442, it strengthens Texas law by requiring written consent for creation of any explicit deepfake material, and then it also expands the legal definition of deepfakes to include audio, images, and media, not just video. It also increases the criminal penalties for those who produce or distribute non-consensual deepfake material. The reason this bill is needed is because current law does not adequately protect individuals from being targeted by AI-generated sexual exploitation. And so right now, someone can take a public photo, say from a campaign website or Instagram, and use it to create any explicit deepfake with no accountability. And so with that, I reserve the right to close.
Okay, any questions for Ms. Fairley? Okay, I have no witness. Well, we do have one witness, so we'll give you the opportunity to close, okay? And so the chair calls Brody Burks. And Mr. Burks, your affirmation shows you're here on behalf of the Office of Attorney General, and you are neutral on the bill, correct?
That's correct. Mr. Chairman, members, thank you for taking this one up. This is a really important bill for us. I know as a member of the Attorney General's office, I'm not allowed to take a position on a bill, but just like we all have children and we're not allowed to have favorites, what I will say is this is a really useful one for us. One of the things that is so useful about this is rather than creating a new offense or doing something that we have to figure out how to use, it takes some language that we already have, that we already know how to use in court, and broadens it definitionally just enough for us to bring in still photos, things like that, as well as the videos that we currently are seeing and prosecuting. Happy to answer any questions that you have.
Any questions for Mr. Burks? Seeing none, we appreciate you being here.
Thank you very
Ms.
much.
Birch. Anyone else here to testify for, against, or on Senate Bill 442? If not, the chair recognizes Ms. Fairley to close.
Thank you, members. I close.
Okay, and so if there's no other questions, the chair will leave Senate Bill, and no objection, the chair will leave Senate Bill 442 pending for now. Members, any further business? I think we've covered all of our bills. If not, we'll try to meet today or tomorrow to vote on some of these bills, and we'll be in touch with you to kind of see when's a good time. So if there's no other business, the Committee on Criminal Jurisprudence will adjourn.